All right, our next file this morning is People of the State of Michigan, actually this afternoon. People of the State of Michigan versus Tanya Lee Brown. File is 25-3642-F8. Appearances, please.
Thank you very much, Your Honor. Attorney Robert Rich, Assistant Prosecutor from Sauk County.
This is for Robert Champion, appearing on behalf of Tanya Brown, who's seated to my left, Your Honor.
Thank you. Do we have a resolution or are we doing a trial?
We have a resolution.
All right.
Your Honor.
Mr. Rachel?
My understanding is the defendant will remain guilty plea to count 2. People will be dismissing count 1 and have.
That's my understanding of the plea, Your Honor.
All right, Ms. Brown, is that how you want to resolve the file?
Yes.
Please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, ma'am?
Yes.
Thank you. May lower your hand. All right, Ms. Brown, I don't remember, back on August 2nd of last year, 2025, were you on probation or parole or bond?
No, sir.
Thank you. You are currently charged on the felony information with 2 counts and a sentencing enhancement. Count 1 is a charge of larceny in the building, which is a felony punishable by up to 4 years and or up to $5,000. There's also a 4th habitual felony offender enhancement that could increase that maximum punishment from up to 4 years to up to 15 years. However, count 1 and the habitual enhancement will be dismissed. Count 2 is a charge of lying to a police officer involving a case where there is a crime punishable by 4 years or more. That itself is a high court misdemeanor punishable by up to 2 years and or up to $5,000. Plus, as a 4th habitual felony offender, that could increase that maximum punishment up to 15 years. However, if you plead guilty to that offense, the prosecutor agrees to dismiss the 4th habitual enhancement, and therefore.
This is a critical legal moment that many viewers might miss. The prosecutor agrees to dismiss the 4th habitual offender enhancement, and that single decision changes everything. Without it, Miss Brown could be looking at up to 15 years. With it dismissed, suddenly the maximum drops to 2. That's the power of plea bargaining. It's not about whether the crime happened, that's already admitted. It's about how the law categorizes the defendant's past and whether the court treats her as a repeat offender at the highest level. When you hear habitual offender, it's not just a label, it's a multiplier that can turn a misdemeanor into a decade-long prison sentence. So when that enhancement disappears, it's not a technicality. It's the difference between a short county jail term and potentially losing a huge portion of your life. And it raises a serious question: should past convictions always carry this much weight, or should rehabilitation reset the scale?
Or keep the maximum penalty as up to 2 years. Is that what you understood?
Yes, sir.
By entering a plea of guilt, you'll not have a trial of any kind, and you'll be given up certain rights that you'd otherwise have at a trial. That includes the right to be tried by a jury, the right to be tried without a jury, if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for defense to appear at trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify at a trial if you choose to testify. Ms. Brown, do you understand those rights?
Yes, sir, I do.
And more importantly, do you understand that if you enter a plea of guilty and accept that plea, you will be forever waiving those rights as they apply to this particular case?
Yes, sir, I do.
Additionally, any appeal as to conviction and sentence pursuant to this pretrial agreement will be by filing an application for leave to appeal and not a claim to appeal by right. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you're convicted at a trial. You also will be given the right to claim that the plea was a result of any promise, threat, or inducement not told to me on the record. Have there been any other such promises, threats, or inducements?
No, sir.
Are you entering the plea of your own free choice?
Yes, sir.
Mr. Champion has probably talked to you about the Michigan sentencing guidelines and tried to give you an idea or estimate as to how he thinks you would score. The highlight for you is it's merely an estimate. You understand?
Yes, sir.
And it's up to the court to determine what those guidelines will be. Do you understand?
Yes, sir.
Also, the guidelines are not mandatory. They are a tool judges have to use, but the results are not mandatory. It's the sentence is up to the discretion of the court. Do you understand?
Yes, sir.
Knowing all that, do you still wish to enter the plea of guilty that we just talked about?
Yes, sir.
Asked to count 2, lying to a police officer involved in a case where there's a felony punishable by 4 years or more. How do you plead?
I plead guilty, Your Honor.
Before the court can accept that plea, I need to have you tell me what it is that you did that makes you guilty of an offense. turning your attention to August 2nd of 2025 in Lake Township here in Missaukee County. What happened?
When the officer questioned me about a set of earbuds, I did knowingly lie to him about having knowledge of the earbuds.
And those earbuds were like headphones that somebody uses for
Yes,
their
sir.
phone. And were they taken from inside of a building or a rental home?
An Airbnb that I cleaned.
Okay,
Yes.
yep, so inside of a building that was being rented, and whether or not you took those or committed.
Listen carefully to what the judge is doing here. He's not just asking, did you lie? He's building the legal foundation that makes the plea valid. The earbuds, the Airbnb, the theft investigation, these details establish that this wasn't a harmless fib. The law treats lying to police during a felony investigation as its own serious crime because it interferes with justice itself. Even if the underlying theft charge gets dismissed, the system still punishes the obstruction of truth. And this is where many defendants get tripped up. They think avoiding trouble in the moment is harmless, but the courtroom later treats that decision as a separate offense with its own consequences. Would you have admitted the truth in that moment, knowing it could lead to charges? Or would you have taken the same risk she did, hoping the lie would never be proven?
The larceny inside the building when you were asked about it by Sergeant Kevin Vorpagel of the Sheriff's Department, you lied to him and told him you didn't take them, which in fact you did. All right.
Yes, sir.
All right, copy. Mr. Ringstrom, do you believe the defense provided a factual basis?
I do, Your Honor.
Are you aware of any other promises, threats, inducements?
I am not.
And you believe the court's compliance with Michigan Rule 6.302?
Yes, Your Honor.
Mr. Champion, you agree?
I do, Your Honor.
The court agrees and finds that the defense plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements for count 2. Count 1 and the enhancement will be dismissed at the time of sentencing. Sentencing will typically be done in about 4 to 5 weeks. Between now and then, an agent from the Department of Corrections will prepare a pre-sentence investigation report. That report will include a description of the offense, description of the pretrial agreement, any statements, information you make or provide while it's being prepared, as well as a score of the Michigan sentencing guidelines, which again are not mandatory, and will make a recommendation as a sentence, which also is not binding upon the court, as it is the court alone that determines the sentence. There are 3 steps that involve you. Number 1, you're going to get a packet. You're going to complete that packet and turn it into the Department of Corrections. Number 2, they'll be subject to an interview with an agent from that office. And number 3, oh wait, by the way, you have to have your counsel present during that interview. And number 3, your counsel will have to meet with you prior to coming back to court and go over that report with you, as each side has the right to make objections or request corrections to the content of the report. Do you understand?
Yes, sir.
All right. Anything from the people?
No, Your Honor.
Mr. Champion, you're standing up. That means you got something to.
This is where the case turns from pure law into human struggle. The defense isn't just asking for bond, they're asking the court to recognize addiction as a medical condition, not just a moral failure. The lawyer talks about methamphetamine, treatment programs, recovery steps, and outpatient care. But the judge has to balance compassion against a documented history of violations. Missed drug tests. New charges. Broken trust. Courts operate on one brutal principle: compliance equals credibility. Once a defendant violates conditions, every future promise becomes harder to believe. So when the judge denies bond, it's not just punishment, it's risk management. The court is saying, you haven't proven yet that freedom equals safety. And that leads to a tough question for viewers: should treatment come before punishment, or must accountability always come first?
Important. Go ahead, sir.
Your Honor, I'm asking the court to reconsider bond in this matter and set it as PR bond. Ms. Brown has now entered a plea to a high court misdemeanor. She wishes to participate in recovery. I'm asking the court for PR bond with immediate enrollment in drug testing, along with the Department of Corrections, Community Corrections Intensive Outpatient Treatment Program. And she's currently working with CMH, and part of that, the bond would be to continue working with.
And Mr. Ringstrom, your position.
Guideline range is going to be 0 to 17 in this, so the court is aware. The reason why she is incarcerated is because
She had violations.
she was violating, not doing her random testing, and they pick up a new charge at that point in time with a driving on suspended license, allegedly, yeah. There's supposedly meth that was found in the vehicle at the time. Or, no, not meth found in the vehicle. I think she failed testing.
Mr. Champion, you're bracing those armrests. Go ahead.
Yes, Your Honor, my client admits that she was addicted to methamphetamine. She's made a great strides since she has been incarcerated. She's been working the steps, she has been working with community mental health. I was going to ask for inpatient treatment, but I thought this would be, given the charge, I thought the intensive outpatient treatment would be a good option for her, and also would give the judge, Your Honor, the ability to evaluate her sentence and her performance on bond awaiting sentencing.
Thank you. All right, I understand the reasoning behind that and the objectives here, but the defendant has violated bond and potentially picked up another charge. I don't know what the status of that is, but I'm going to leave the defendant right where she's at until we get back here for sentencing. She wasn't testing, wasn't doing what she's supposed to, and I think we had a couple issues, so therefore
That short sentence, "I'm going to leave the defendant right where she's at," carries enormous weight. It means jail continues. No release. No outpatient. No second chance at liberty before sentencing. Judges rarely enjoy making this call, but public safety and court integrity come first. When conditions are violated, the system shifts from trust to control. This moment also shows how plea deals don't guarantee leniency in every area. You can get enhancements dismissed and still remain incarcerated. Legal relief in one area doesn't erase behavioral history in another. Do you think the judge made the right call here, or should recovery efforts outweigh prior violations?
court's going to deny the bond modification. Thank you very much. We are adjourned. All right, our next case is going to be People of the State of Michigan versus Annette Wheeler. This is going to be case number 25-44FH. Appearance, gentlemen.
Speaker David Denton on behalf of the people.
Robert Champion hearing on behalf of Ms. Wheeler. I anticipate this to be a plea, Your Honor.
All right, thank you. In this particular file, Ms. Wheeler is one of those cases set for trial on January 20th. She is currently charged with operating while intoxicated as a third offense with a fourth habitual felony offender enhancement. I was hoping she'd be brought in while I was talking, but we had a couple more minutes.
Yeah.
Did you get new glasses?
Yes, thank you for kindly noticing.
Been kind of a busy day, Linda. Give me a break.
It's been over a
Well-
month.
We're in recess.
It's been the holidays. We haven't seen much of it.
No. I was gonna say, you kind of look like Harry Potter. Do you have a thing in your forehead? Husband's not making you sleep underneath the stairs again, is he?
Who else like those round glasses? Do you remember Channing, Carol Channing?
Oh, yeah, yeah.
Linda needs to learn to sing Diamonds Are a Girl's Best Friend.
All right, we are back on the record. People versus Wheeler. Mrs. Wheeler has been brought here into the courtroom. The attorneys are still present. The counsel told me that they anticipate a resolution of this case. Mr. Denham, why don't you go ahead and tell me what the pretrial agreement is?
Thank you, Your Honor. It's my understanding that Ms. Wheeler will be accepting the people's offer, which is to plead to count 1, OWI third, as a have second offender. In exchange, the people will be dismissing the have fourth notice, Your Honor.
That's my understanding, please, Your Honor.
Thank you. All right, Ms. Wheeler, have you heard what the attorneys have told me is the resolution in today's case?
Yes, sir.
Is that how you wish to resolve it?
Yes, sir.
To the best that you can, please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, nothing but the truth?
Yes, sir.
You may lower your hand. All right, Ms. Wheeler, or Mrs. Wheeler, looking back here on October 9th of 2025, were you on probation, parole, or bond?
No, sir.
Thank you. You are currently charged on a piece of paper called a felony information with 1 count and a sentencing enhancement. Count one is the charge of operating a vehicle while intoxicated as a third offender. Now, that's a felony with a minimum of 500 to a maximum of $5,000 in fines. And then either a minimum of 1 year to a maximum of 5 years in prison, or in the alternative to prison, probation with a minimum of 30 days in jail to a maximum of 1 year in jail, where at least 48 hours must be served consecutively, and there could be a minimum of 60 days to a maximum of 180 days of community service, plus rehabilitative programming, costs for rehabilitative programming and emergency responses, as well as for prosecution of the defendant, plus mandatory vehicle immobilization of the vehicle for not less than 1 year, but not more than 3. Now, there is what's called a fourth habitual felony offender enhancement. That means that if you were convicted with that enhancement still there, the maximum punishment could be increased from up to 5 years to up to life. However, the prosecutor.
Now we move into a much heavier charge. Operating while intoxicated as a third offense is no longer a simple DUI, it's a felony with mandatory jail, potential prison, fines, immobilized vehicles, and long-term license consequences. And when the judge explains that a fourth habitual offender enhancement could raise the maximum to life, that's not courtroom drama, that's statutory reality. This is the law's way of saying, repeated dangerous behavior eventually crosses into extreme punishment territory. Even though that enhancement gets reduced to HAB2, the ceiling is still massive. This moment forces viewers to confront a serious issue. At what point does repeat drunk driving stop being seen as a mistake and start being treated as a life-threatening pattern?
And the defense counsel tell me that you'll be pleading as a habitual felony offender second. What that does is it increases the maximum punishment. Instead of from up to 5 years to up to life, it increases it from up to 7 years to up to 7.5 years. Okay, there's also some other impacts on what are called the sentencing guidelines, but I'm not going to go over those at this time. So far, is that what you understood was the pretrial agreement today?
Yes, sir.
Now, if I enter in this plea, if I accept that plea, you're going to be waiving certain rights and not have a trial. That includes the right to be tried by a jury, the right to be tried without a jury, if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for your defense to appear at trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify if you're to choose to testify at a trial. Ms. Wheeler, do you understand those?
Yes, sir.
And again, do you understand that if you enter a plea of guilty today and I accept that plea, you'll be forever waiving those rights as it applies to this particular case?
Yes, sir.
Additionally, any appeal as to the conviction and sentence pursuant to this pretrial agreement will be by filing what's called an application for leave to appeal and not an automatic or claim to appeal by right, which is only guaranteed when someone's convicted at a trial. You also may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You will also be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record, or the plea was not of your own free choice. Are you entering this plea of your own free choice?
Yes, sir.
Have there been any other promises, threats, or suggestions to get you to plead guilty other than the terms we just talked about?
No, sir.
Now, Mr. Champion has probably gone over the Michigan sentencing guidelines with you, try to give you an idea or estimate as to what he thinks you could be sentenced to. Has he or anyone promised you or led you to believe exactly what the sentence would be?
No, sir.
Now, if he did talk to you, which I highly trust that he did, about the Michigan sentencing guidelines, I want to highlight for you that whatever he told you is merely an estimate. I don't know what they're going to be, and the court will determine them at the time of sentencing. Also, I want to highlight for you that they are not mandatory. The court can go above them, below them, or right in the middle, but the court must use them to establish a reasonable and proportionate sentence. Now, before I take the plea, do you have any questions for me about what we talked about?
No, sir.
Okay. As to count one, how do you plead?
Guilty.
Now, before the court can accept that plea, I'm going to have you tell me what it is that you did that makes you guilty of that offense. Turning your attention to October 9th of 2025 here in the city of Lake City in Missaukee County. Were you operating a vehicle on a roadway?
Yes, sir.
And it looks like that was over on North Blodgett Road. Is that
Yes,
right?
sir.
Yes, sir.
and somewhere near Walker Road, which is also known as M42. Does that sound right?
Correct,
And were you stopped by law enforcement while you were driving?
correct.
And before driving or while driving, had you consumed some alcohol?
Yes, sir.
And Mr. Denhound, do we have an intoxilizer or intoxilizer or blood draw?
Yes, Your Honor, the intoxilizer 9,000 results were 0.178, 0.176. Your Honor.
A 0.178 and 0.176 blood alcohol concentration is more than twice the legal limit. At that level, reaction time, judgment, and motor control are severely impaired. This isn't one drink too many. This is extreme intoxication behind the wheel. The law treats numbers like these as aggravating factors because they show elevated danger to the public. When the defense stipulates to the intoxilizer results, they're conceding scientific proof. No argument. No challenge. Just acceptance. It's a reminder that modern DUI cases often hinge on data, not just officer testimony. And the question becomes, should high BAC levels automatically mean harsher sentences, regardless of personal circumstances?
Mr. Champion, does the defense so stipulate for the taking of the plea and for sentencing?
Yes, Your Honor.
All right. Ms. Wheeler, is it also true that looking back in 2015 on April 28th, in looks like the 65th District Court, you were found guilty of operating while intoxicated? That would be downstate?
No.
All right. Well, and do you have 2 prior drinking and drivings?
Yeah, October or March of 2016,
Okay.
and then August of 2016.
All right. I see this September, which was probably when the plea
Yeah,
was,
okay.
and that's 2015. That was September 30th. Is
I
that
may
right?
be wrong, sir.
All right. Do we want to change those, Mr. Or does this defense so stipulate?
I'll stipulate to those, Your Honor. I believe those were the arrest dates.
Yeah, thank you. And so we have it for May 28th. Mr. Denham, do you believe she's provided a factual basis to support the taking of the plea?
I do, Your Honor.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
And do you believe the court's in compliance with Mr. Kroll 6.302?
Yes, Your Honor. And is that for the half second, did the court acknowledge?
No, I haven't yet. Good, thank you. I'm
Thank you.
sitting there like, I know there's something I'm forgetting. Let's go ahead and go with the oldest one. Ms. Wheeler, is it also true that you were convicted of operating while intoxicated as a third offense in this court back on March 6th of 2023?
Yes, sir.
All right, now do you believe the court's compliant with the court rules?
Yes, Your Honor.
Mr. Champ, do you agree with all 3?
I do, Your Honor.
All right, the court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record, in addition to the stipulation as to the intoxilizer result, satisfies the elements for count 1, as well as the habitual felony offender second. Therefore, she is found guilty of those, and the 4th habitual enhancement will be dismissed at the time of sentencing. Ms. Wheeler, the case will now be set for sentencing. Sentencing will be generally in about 4, maybe 5 weeks from today's date.
The pre-sentence investigation report is one of the most powerful documents in criminal court. It shapes sentencing more than almost anything else. It compiles criminal history, treatment records, compliance patterns, and personal background into a single narrative that the judge relies on. Even though the guidelines are not mandatory, they strongly influence the final outcome. This is where defendants' past choices come back in full detail. Every missed appointment, every relapse, every prior success or failure is weighed. It's not just about the crime, it's about the person's entire relationship with the law. This stage often determines whether someone gets probation, jail, or prison.
Between now and then, an agent from the Michigan Department of Corrections, also known as the Probation or Parole Office, will prepare a pre-sentence investigation report. That report will include a description of the offense, a description of the pre-trial agreement, statements or information you make or provide, as well as information about any prior criminal history, prior performance on bond, prior performance on parole or probation, as well as alcohol treatment, things like that. It will also include a scoring to guidelines, which again I highlight for you are not mandatory. It will also include a recommendation as a sentence. Please keep in mind that it is merely a recommendation as I make the determination of the sentence. Do you understand?
Yes, sir.
There are 3 steps that involve you, the preparation of this report. Number 1, you're going to get a packet in the jail. You're going to fill it out, turn it in. Number 2, you'll be subject to an interview with an agent from an office, and you have the right to have Mr. Champion present during that interview. And number 3, prior to coming back to court, probably about 10 days to 2 weeks before, Mr. Champion is going to meet with you and go over that report, because each side has the right to come back to this court and request corrections or make amendments to the contents of the report before the court uses it to give a sentence. You understand?
Yes, sir.
All right. Do you have any questions about what we have done today, ma'am?
No, sir.
Mr. Denhoughton, anything further?
No, Your Honor.
And Mr. Champion, go
I
ahead.
have a question. Ms. Wheeler has been waiting to attend or to participate in patient treatment. She had a bed available quite some time ago, but that was in Saginaw, not part of the program that Community Corrections currently uses. I do not have a current bed available for her. We are working on that. Would the court wish me to file a written motion to address that at a later time?
I think that's best. Mr. Denhoughton?
I was just gonna oppose the request for a number of reasons. I don't know if the court would like me to give those reasons now or.
Well, right now, I've already said, right now, all you got to do is say, Judge, I oppose, because it's not written, it doesn't have the proper notice.
I would do that, Your Honor.
Boom. Now it means he's got to file a motion, and then you can file your response at the time. And of course, I suspect at that time, you'll be able to tell me how she's done on bond, probation, parole in the past, and what or how she scores on the guidelines. So at this time, the court's going to revoke bond, remand her to the custody of the Missaukee County Jail. And then if the defense chooses to file that motion, we'll consider it at that time.
Thank you.
All right. Thank you very much. We are adjourned. Our next file is People of the State of Michigan versus Emmerich, Mayberry, Crosby. This file number is 25-3645 FH. Appearances, please.
David Denhoughton on behalf of the people.
Champion appearing on behalf of Mr. Crosby.
Thank you. We are here today for a final pretrial conference. What's going on today, gentlemen? Mr. Denham, terms?
Yes, Your Honor. It's my understanding that the defendant will be pleading guilty to count 1 OWI as a third offender. There is a 100 restitution to Missaukee County as part of this plea. The guidelines that I projected are 0 to 9 months. There is a pending referral to sobriety court that it's not a killer agreement, but we would not be opposing that with the standard terms if the defendant would be accepted here.
So pleading to count 1. No opposition to sobriety court. $100 restitution, dismissal of counts 2 and 3.
Yes, Your Honor.
Mr. Champion?
That is a correct statement, Your Honor.
Thank you. Mr. Crosby, is that how you wish to resolve the file today?
Yes, sir.
Please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, nothing but the truth?
Yes, sir.
You may lower your hand. All right, Mr. Crosby. Have you heard what the attorneys have said?
Yes, sir.
All right, and so looking back here on October 15th of 2025, were you on probation?
Yes, sir.
And where were you on probation?
Missaukee County,
And what offense or what were you on probation for?
OWI second.
And have there been any probation violations taken against them, Mr. Champion?
They have, and they've been resolved, Your Honor.
All right, thank you. Were you on probation or bond or anywhere else at that time?
No, sir.
Thank you. You are currently charged on a felony information, which is simply a piece of paper with 3 counts. Count 1 is a charge of operating a vehicle with a blood alcohol content, while intoxicated with a blood alcohol content higher than 0.08 grams per 210 milliliters of breath, and that's as a third offense. That makes it a felony punishable by a minimum of $500 to a maximum of $5,000. And then either a minimum of 1 year to a maximum of 5 years in prison, or in the alternative to a prison sentence, a period of probation with a minimum of 36 days in jail to a maximum of 1 year in jail. And 48 hours must be served consecutively. Additionally, The court could assess a minimum of 60 to a maximum of 180 days of community service. Plus, it can assess cost of rehabilitation, cost for prosecution, and reimbursement for emergency responses. Plus, there would be mandatory vehicle immobilization of the vehicle, not less than 1 year, but not more than 3 years. I'm told today you're going to enter a plea of guilty to that offense. Now, there are 2 other charges that will be dismissed. Count 2 is operating a vehicle that's unregistered. That's a misdemeanor punishable by up to 90 days and or up to $100. Additionally, count 3 is a charge of operating a vehicle without security, also known as insurance. Now, that's a misdemeanor for which the maximum punishment is up to 1 year and not less than $200, but not more than $500 in fines. Plus, the Secretary of State can take sanctions against your license separately, but that is done by the Secretary of State and not by the court. You understand? Now, those last 2 counts again are going to be dismissed. Now, there's a couple other terms of agreement. Number 1, there's an agreement that you're going to pay $100 in restitution to the prosecutor for their prosecution fee. And then there's something called a sentence agreement, but it's not solid. Here's what I mean by that. Sometimes a sentence agreement can be right where today I would agree and the prosecutor.
Sobriety court is not an easy option. It's an intensive, long-term program with constant monitoring, treatment, testing, and judicial oversight. But it can mean the difference between a felony conviction and a reduced charge. The judge makes it clear, this is not guaranteed. It's earned. And failure means harsher consequences later. The system is offering structured rehabilitation instead of straight punishment, but only if the defendant proves absolute commitment. This raises a powerful issue. Is specialized treatment court a privilege, or should it be a standard response for repeat substance-related offenses?
And you would agree exactly what the sentence is going to be. I don't do those. They're called the Cobb's agreement. I don't like them. They don't make any sense to me. Plus, it's because I often don't know a lot about you, right? There might be something else out there that's going to swing that I may not know about today that they find out about later. So I don't do those. The other is a killer rule agreement, where you and the prosecutor make an agreement, such as putting you in sobriety court. And if I don't go along with it, you would have the right to withdraw your plea and come back to the stage of the proceedings. However, there is no killer rule agreement. It's merely an agreement by the prosecutor not to oppose me putting you in sobriety court. So that means that if you get accepted into the program and you and your counsel ask me to place you into it, the prosecutor is not going to say, don't do it. It's going to be strictly up to me. Now, I generally have a pretty good record of placing people in the sobriety court program, unless they've been to the program before, they've got multiple felony convictions or whatever. But generally I put people into it, but there's no promise. Do you understand that?
Yes, sir.
Knowing all that, do you still wish under the plea of guilty that we talked about?
Yes, sir.
And by entering a plea of guilty, you'll be given up certain rights and not have a trial. That includes the right to be tried by a jury, the right to be tried without a jury if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear trial, the right to question or cross-examine those witnesses against you, the right to have the court order any witnesses you may have for your defense to appear at the trial, the right to remain silent during the trial, the right to not have its silence used against you, and the right to testify at the trial if you were to choose to testify. Mr. Crosby, you understand those rights?
Yes, sir.
And even more importantly, do you understand that if you enter a plea of guilty today and I accept that plea, it will be forever waiving those rights as they apply to this particular case.
Yes, sir.
Additionally, any appeal as to the conviction and sentence pursuant to the pretrial agreement will be by filing an application for leave to appeal and not what's called an automatic or claim of appeal by right. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. Also, you will be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record. Are you entering this plea of your own free choice?
Yes, sir.
Other than the terms that we've already talked about, have there been any other promises, threats, duress, coercion to get you to plead guilty?
No, sir.
And Mr. Champion has probably talked to you about the Michigan sentencing guidelines. I want to highlight for you that whatever he's told you is merely an estimate as to what he thinks that range could be. You understand?
Yes, sir.
And it's the guidelines are not mandatory. It's up to the court to establish the sentence. Do you understand?
Yes, sir.
All right. I got it all. Has anybody led you to believe exactly what the sentence would be? I forgot if I asked you that.
So does anybody friend?
No. Has anybody led you to believe an exact sentence?
No.
All right, all right. Therefore, you still wish to enter the plea as we discussed?
Yes, sir.
As to count one, operating a vehicle while intoxicated is a third offense. How do you plead?
Guilty.
Before the court can accept that plea, I need you to tell me what you did that makes you guilty of that offense. So turning your attention to October 15th of 2025, here in the city of Lake City in Missaukee County, were you operating a vehicle?
Yes, sir.
Looks like it was over on Mitchell Street,
Yes, sir.
and were you stopped by a police officer?
Yes, sir.
And prior to or while driving that vehicle, had you consumed some alcohol?
Yes, sir.
Mr. Denholm, are there any toxilizer or blood draws?
Toxilizer results, Your Honor. And they were 0.09 and 0.089.
Mr. Champion, does the defense so stipulate?
Yeah, I do, Your Honor.
Thank you. All right. Mr. Crosby, is it also true that back on September 27th of 2021, in the 53rd District Court, you were convicted of operating while impaired?
Yes, sir.
And is it also true on or about July 7th of 2025 in the 84th District Court, you were convicted of operating while impaired as a second time?
Yes, sir.
All right. Mr. Denholm, do you believe the defendant provided the factual basis?
Yes, Your Honor.
Are you aware of any of the promises for inducements?
No, Your Honor.
Do you believe the court's compliance with Parole 6.302?
Yes, Your Honor.
Mr. Champion, do you agree?
I do, Your
All
Honor.
right, thank you very much. The court agrees and finds the defendant's plea today is made freely, felony, and voluntarily. The court further finds the testimony provided by the defendant under oath, in addition to the stipulation of the blood of the alcohol, blood alcohol content, satisfies the elements for the offense. Therefore, the defendant is found guilty of count one. Counts 2 and 3 will be dismissed at the time of sentencing. And between now and then, a pre-sentence investigation report is to be prepared by an agent of the Michigan Department of Corrections. This report will include a description of the offense, description of the pretrial agreement, any statements, information you make or provide while the report's being prepared. You will get a packet, you'll complete it, turn it in. You'll have an interview with an agent from that office. You have the right to have Mr. Champion present. A week or so before coming back here to court, Mr. Champion will sit down and go over that report with you to make sure that it's correct, because each side gets the right to come back to the courtroom and request corrections or make objections to the content of the report. The report will include a scoring of the Michigan sentencing guidelines, which again are not mandatory, and it will also make a recommendation as to the sentence. Please keep in mind it is merely a recommendation, as it's the court alone that determines the sentence. Do you understand, Mr. Crosby?
Yes, sir.
All right, Mr. Champion.
Your Honor, I'd like to respond.
Denhout, any objection?
Not to the consideration, but we do object to the request for relief, further relief. If that
Oh,
makes- if that
You
makes-
object to the relief requested, but you allow him to make the request this time.
Yes, sir.
Go ahead, Mr. Champion.
My client has 3 criminal convictions. They're all drunk driving. The most recent 2 were in 2025. He's 28 years old. He has strong family support, and also his employer is holding his job in this situation. I believe, based upon his criminal record, based upon the facts, he is a strong candidate for sobriety court. He has a job waiting for him at this time. He's been incarcerated now for a little over 2 months. With that, I would ask the court to consider releasing my client on PR bond with the scram or the alcohol tether.
Okay, did he get a sanction for the district court probation?
Did, Your Honor.
Okay, thank you. Mr. Denhout, thank you.
Yes, Your Honor. So as the court may be aware, but the defendant was on probation at the time of this offense for operating while visibly impaired. He did receive a sentence of 93 days jail. That was back in October. The court at that time did authorize work release. I simply wanted the court to be aware of that
Yeah.
background, Your Honor.
I got it. All right, thank you.
So the court's, it's also offered in this case, but it's not available to him until he's sentenced.
Right, I got it. All right. The court will modify the defendant's bond as follows. The court
This is a sharp contrast to the first defendant's outcome. Here, the judge grants PR bond with strict conditions, scram alcohol monitoring, random drug testing, and zero tolerance. It shows judicial discretion in action. 2 addiction-related cases, two very different risk assessments, two very different decisions. The court is signaling cautious optimism, freedom, but under surveillance. Trust, but with technology watching every hour. And it makes you wonder, what tipped the scale here that didn't earlier?
Release the defendant on his own personal recognizance. The defendant is required to go to the community corrections office in Cadillac. And he is not to use or possess or consume any controlled substances, including recreational marijuana and alcohol. He is to be subject to random testing. He will also be put, for the controlled substances. For the alcohol, he will be put on a daily monitoring, which is the SCRAM device. All right.
You said it's subject to random for the control?
Random testing for drugs, but SCRAM is for alcohol. All right, the court will also order the defendant to begin
That would be,
go ahead. It seems to be by the time he even gets it started, he's gonna stop, because then he's gonna go do the sobriety court program, presumably.
that's what I'm anticipating here.
Yeah, so, all right. I think I've got enough. All right. So you'll be released today. You're gonna get that packet today from our probate. Well, maybe they'll give it to you over at the jail before you leave today. Detective, he's shaking his head, yes. All right, make sure you can fly and turn it on. Let's be really honest here. What happens if you test positive for alcohol or drive a car?
I believe I would go to prison, Your Honor.
Well, I don't know if you're gonna go to prison, but I guarantee you're not gonna get sobriety court.
Right.
Okay, now, we didn't talk about this very well. Gosh darn it. Sobriety court means that if I place you into it as a 2-year program, 1 year, I delay your sentence. You go down there, you do the program in district court, and then it comes back. They tell me, hey, judge, he's doing really bad or he's doing really well. Then I get to decide, I'll keep him in the sobriety court program, and then I refer the case down to district court. And then if you complete it, you get the charge withdrawn from a felony down to down to an operator want to talk to second, which is a misdemeanor punishable by 1 year and up to $1,000. And you can do that program for 2 years. So if I put you into the program, only really care about the 1 year. Okay. By the way, if you go to a sobriety court program and they come back and say, hey, judge, he's been here for a year, we still think he should complete the program.
The judge's explanation is blunt and honest. Sobriety court is a test, not a favor. 1 year of strict compliance before any sentence reduction is even considered. Relapse, dishonesty, or violations can erase the opportunity entirely. This moment shows how the justice system blends hope with hard boundaries. It offers a path forward, but only through discipline and proof of change. Would you be able to live under that level of supervision for a year or more?
By the way, he is tested positive 8 times, 10 times. I'm going to say, no. Got it? All right. Do you still in favor of the pretrial agreement and the plea? All right. The court reaffirms the findings. Thank you very much. We are adjourned.
Today's courtroom revealed the full spectrum of criminal justice in action: plea bargaining that removed life-altering enhancements, factual admissions that sealed guilt, judges weighing addiction against accountability, and treatment options balanced against public safety. We saw how the same law can lead to incarceration in one case and conditional release in another, depending on history, compliance, and risk. We also saw how sentencing guidelines, habitual offender statutes, and sobriety court programs shape outcomes far beyond the single moment of arrest. In the end, every defendant accepted responsibility, but the court made it clear, responsibility must be followed by behavior that proves change. If you found this case as intense and revealing as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more in-depth, jaw-dropping courtroom breakdowns where law, psychology, and real-life consequences collide.